I commend the bill.
Honourable David Parker.
Mr Speaker, I want to catalogue some of the areas where I was unhappy with this process, because I think that we came close to getting it wrong in this Parliament, and would have but for the circumstances that Charles Chauvel has already outlined, which involved all of the minor parties lining up with Labor to stop the National Party pushing this through without a select committee process under urgency. Mr Speaker, the Supreme Court decision threw up three issues which the government conflated. Those three issues were: did the police and some other agencies need a prospective power of surveillance, which the Supreme Court found does not exist until this legislation passes? Secondly, what would be the effect of the decision on prior convictions? And thirdly, what would be the effect on illegally obtained evidence in light of, or illegal in light of, the Supreme Court decision in respect of trials that have yet to take place? Now, it wasn't until we got to select committee and had input from other parties, including the Labor Party, that clarity in respect of those three issues was, or light was started to be shone on those three issues. And once we did that, it was easier then to cure the problem. Can I say that I am disappointed and extremely surprised that yet again we've had a failure of Parliament's processes in respect of the Bill of Rights vet. The Bill of Rights requires the Attorney-General to report to Parliament where any legislation breaches the Bill of Rights. We have averted to this in our minority report. And Mr Speaker, on this occasion we did not have a report from the Attorney-General signalling that this legislation infringed the Bill of Rights, and it has taken Labor to elucidate that in our minority report. The Supreme Court found that the police acting without express authority in the use of surveillance devices was in breach of the Bill of Rights, and that stands as the ratio of their decision. This legislation, as it was introduced to the House, retrospectively made that illegal evidence legal. That must infringe the Bill of Rights provisions in respect of freedom from search and surveillance that is inappropriate. Mr Speaker, how could the government conclude that no Bill of Rights warning was necessary for this House? It would have highlighted to the House that care needed to be taken in respect of the retrospective application of this legislation, which the Select Committee did get to the bottom of, but not to the thanks of any warning that was properly required under the Bill of Rights Act. Now, that's not a fault of the Attorney, because in respect of this he had delegated this to Kate Wilkinson, and in fairness to her, she acted on advice from the Department of Justice. But that is the third instance in this Parliament where we have, in my opinion, had poor process within the ministry advising ministers that no Bill of Rights vet was necessary. We had it in respect of the earlier attempt to remove the unconditional right of an accused person to appear at their own defence when they wanted to. We also had it in respect of some of the provisions which were going to effectively abrogate part of the right of silence of defendants when, in the criminal procedure legislation, the defence was going to be required to disclose the nature of their defence to the prosecution. And we've had it again in respect of this legislation. And I would say to the Attorney that there is a need to review that office, because these are three instances where I think there have been Bill of Rights complications that ought to have been brought to the attention of this House. Mr Speaker, can I say that in respect of the prospective power of the police, I am disappointed with the attitude of the Greens. It is absolutely clear that the police need on some occasions the right to surveillance techniques. It's absolutely clear. The Select Committee were told of one example which speaks volumes, and that was drug dealers who know that they might be subject to listening devices close the curtains and they write instructions on whiteboards, and the only way that the police can gather evidence in respect of that is through the use of cameras. That is the only way, and for the Greens to deny that a prospective power is necessary for the police is quite wrong. Mr Speaker, the other point I would raise is that is true also of the SIS. The SIS are affected by this legislation. I was disappointed that I only learned that at Select Committee. It might have been raised at briefings prior to some other people, but it wasn't raised with me, and it wasn't raised in any of the minister's speeches in the first reading. This legislation doesn't just apply to the police, it applies to other agencies. Mr. Speaker, this legislation could have been better. As Sir Geoffrey Palmer said, within a day's drafting, we could have specified that it was a warrant only from judges. We could have listed the level of seriousness before the police can exercise this sort of warrant. We could have had a list of the agencies to which it applied. If we had had that, we would have greater protections than this bill provides. Having said that, the Labor Party is satisfied to vote for it because we do accept that a prospective power is needed for the police. We are pleased that there is not retrospectivity in respect of the trials yet to take place, and we do think it's appropriate that we not reopen convictions that have previously been entered. Thank you, Mr. Speaker. We will be supporting this legislation with those reservations.
Mr. Speaker.
Keith Locke.
Thank you.